A Los Angeles City Councilman faces corruption charges. This may be why Alec Baldwin's charges were dismissed. Brian Kohberger doesn't want anyone to know what his legal team is examining from the lockup. Delphi Murder suspect is to appear in court, and guess what? He wants some of that key evidence not to be used at trial. And then finally, our dumb criminal of the day. He almost did it correctly. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and remember, you can listen to us anytime on any of your favorite podcasting apps. All right, the product sponsor today, CrimeTalkSearch.com. Go there, sign up for that background subscription search. You're going to be happy you did, because you're going to be able to find out if somebody is the real deal or if maybe they're not being completely honest with you. Do they have a criminal history? Are they on a public registry? Do they have liens? Do they have judgments against them? This is the only way you're going to be able to find out, other than maybe go and hire your own private investigator. So go to CrimeTalkSearch.com, get that information that you need, check them out. All right, let's go ahead and open the docket for June 14th of 2023. First, a Los Angeles City Council member has been charged with embezzlement, perjury, and a conflict of interest, and he is becoming the latest in a procession of elected city leaders accused of corruption. Can you imagine such a thing? So prosecutors allege that Curran Price, now this guy's 72, a former state legislator, and has represented the South Los Angeles area on the city council for the last 10 years. And he apparently voted on projects that benefited developers who paid his wife a consulting fee, a total of more than $150,000 between 2019 and 2021. I'm not sure why anyone is surprised by this. This is how politicians make their money. Do you really think the paltry salary that a politician makes is enough to get by on and survive? No. So what happens? They, the politicians, open up a consulting business so they can consult on, other matters and get paid for it, obviously. Hint, hint. Or their family members set up businesses and consulting businesses that just coincidentally, people that have business before the politician can hire them. I mean, could you imagine such a thing? That's their MO. They've been doing it for hundreds of years, and until it is put to a stop, the process will continue. I don't care if you're a city councilman or even a sitting president. Neither you nor your family members should make any money while you are in elective office. Remember, it's called public service. When my clients have to do public service, they have to pay for insurance in case they get injured on the job so they don't sue somebody. They don't profit from their public service. Anyway, the city councilman, the allegations were tied to 3 perjury counts and 2 conflict of interest counts. Now, Mr. Price was also accused of improperly receiving almost $34,000 in medical coverage for his current wife while he was still legally married to another woman, resulting in the embezzlement charges. Now, a spokesperson for Mr. Price said that he was completely blindsided by these allegations, but less than 2 hours later, Mr. Price had stepped down as the president pro tem and relinquished his committee assignments, although he has not resigned from his seat to continue to get that exorbitant salary, I'm sure. And he put out a statement saying, while I navigate through the judicial system to defend my name against unwarranted charges filed against me, the last thing I want to do is be a distraction to the people's business. He put that in the letter to the city council president, and he says, I look forward to having the opportunity to continue to be a strong voice for the culturally rich South Central, a part of the city that has long been disenfranchised, overlooked, and forgotten. Now, an arraignment has not yet been scheduled for Mr. Price, and he has not been arrested. And under the California state constitution, apparently, Mr. Price does not need to be taken into custody because there was nothing to suggest that he would be a flight risk or a danger to the community. That's right, he was only a danger to the community while he was in public office. Just my thought, ladies and gentlemen. That's why public servants and anyone, frankly, in the government should be there no more than, say, 4 years. That way, if there's any hanky-panky going on anywhere, the new people can find it and these people can be prosecuted just the way it is. Next on the docket, maybe this is why Alec Baldwin got his case dismissed. As you know, Alec Baldwin was charged as related to the shooting death of the cinematographer in New Mexico, but those charges were ultimately dismissed against him. However, the armorer on the case, Hannah Gutierrez-Reed, her charges were not dismissed, but perhaps this is why Alec Baldwin did. Apparently, the prosecutors in the case are saying that they have witnesses who will testify that the armorer, Hannah Gutierrez-Reed, was, let's just say she was a party animal. And that they believe these witnesses will be able to testify based upon their experience, provide an opinion that she was likely hung over when the live bullets were loaded into the gun. However, Ms. Gutierrez-Reed's attorney says this is just a character assassination and there's no way that she was in fact drunk. And they're trying to pin this all on her. Well, that's what trials are for. We will have to wait and see. Next on the docket, the Brian Kohberger case. What is it that they want to send out from evidence to be tested? Well, we will probably never know, at least not for a while. So the defense and the prosecution have filed a stipulation, which is just a fancy word for an agreement. And not surprisingly, the court has gone along with it and said, that's fine. So what is it? Well, the prosecution and the defense does not want anyone to know what they are removing from evidence for third-party forensic evaluations. This is certainly something that can be prohibited from public view, and of course, like I said, the judge went along with it. Now, I hate to speculate, but that's what you get when the government, and in this case, the Brian Kohberger defense, doesn't want to share actually what is the truth. It's called facts. It could be the sheath with the suspected DNA on the button, perhaps. It could be clothing. It's likely not electronic devices, but the defense could ask to evaluate those independently. But normally when they download your electronic device, a phone, something to that effect, it is a clone or a mirror of exactly what is there. What it really gets interesting in is that, well, they have to dump the whole phone to then limit the search of it, which is kind of weird because, well, that would be an overly broad search. But then they say, but we're not searching it. We just dumped it. And then we're going to limit our search. So we'll have to wait and see. Now, I have had a situation where we had to take out literally human remains to be taken from custody, put in a box, and sent for an independent autopsy in California. We had to lay out exactly what we were doing, who was going to do the examination, how the bodies were going to get there, and how they were going to be returned back to the government's custody. In this particular case, we had an investigator check the remains out. The government put them in a box. That's right, a FedEx box. They were literally remains to see if they could determine a cause of death. And then when they were done, they shipped it back. That was in a double homicide case regarding children. I don't understand what the big secrecy is. Anyone could have walked into that courtroom, taken a look at the public file, and we could see exactly what took place. I just don't get the secrecy. I really don't get the secrecy. Speaking of secrecy, let's talk about Lori Vallow. Not surprisingly, the hearing for Lori Vallow that's set tomorrow, that's right, that's the hearing where they're going to argue for a new trial. Well, the request for video and audio recordings of the hearing has been denied. That doesn't surprise me. The only thing that surprises me is that it may actually be held in an actual courtroom. I guess we'll still have to wait and see. Now, as you may recall, the defense filed a motion for a new trial, first alleging juror misconduct, some confusing instructions, and how the judge inappropriately allowed the prosecution to amend the charging document, the indictment, to a different subsection of the statute that the prosecution didn't realize their mistake for 2 years. And obviously that was denied just before the prosecution closed their case, and they realized their mistake. And the court even said, well, wow, it seems kind of surprising. Nobody noticed this over the last 2 years. Now, the defense said, hey, Judge, we noticed it, and we've been asking for the last 2 years. Okay, Judge, you told us this is the statute. The prosecution had said this is the statute, and they're going to argue that they prepared their defense based upon that statute. And then the fact that they got to change it is basically not fair. If I had been the judge, and a good judge would have said, nope, you're stuck with your statute. And guess what? Court could have granted a motion for judgment of acquittal at the halftime after the prosecution rested their case. But Judge Boyce allowed the prosecution to amend their case. I think that is the strongest argument. But guess what? It is going to be denied. No surprise here. Obviously, Lori Vallow has been convicted, and there's little doubt that she was involved in the conspiracy to kill J.J., Tylee, and Tammy Daybell. But it is a pet peeve of mine when the judge literally helps the prosecution at every stage of the process, and the prosecution is still wrong, and the judges help cover up for them. And that's what took place. I'll say it again. These prosecutors messed it up, and a judge with a real backbone would have spanked them down. Now, we want justice, but is it really justice for basically the prosecution and the court to say, you know what you have to defend against, and then literally they pull the rug out right before they end their case? It's just not fair. No, don't get me wrong. I cannot imagine Judge Boyce granting a new trial, although he certainly could he could say, we're going to do it in April 1st of 2024 when Chad Daybell goes to trial. He's not going to do that. He wants to get this case over with, and he wants to move along. Therefore, he'll let the appellate courts deal with it, which will probably not give it any substantive thought, and will say, what's the harm? I get it. I'm not a fan of Lori Vallow, but, like I said, if we let them railroad guilty people, then guess what? The government thinks that they can do it to the innocent people as well. Next on the docket, the Delphi murders. Richard Allen obviously is facing 2 counts of murder in the slayings of Abigail Abby Williams and her friend Liberty Libby German, whose bodies were discovered in a wooded area just off the Delphi Historic Trail System. Now, Abby and Libby vanished while walking the Monon High Bridge Trail near Delphi, Indiana, back on February 13th of 2017. And the trail goes about an abandoned stretch of area that was once the Monon Railroad and crosses an old trestle over a small river creek. The girls were found deceased the next day in the area near the trestle, and their deaths were determined to be homicides. Well, the attorneys for Mr. Allen filed a motion in limine, which is basically a pretrial motion asking the judge to say, Judge, don't allow this evidence in to trial. And what is that evidence? It is the evidence, the most important evidence in this particular case, and that is evidence regarding the examination of firearms and ammunition, and we'll see if the court is going to allow it in. My guess is she will. Now, for those who don't recall, the cause of death of the 2 young victims has never been released. However, we know from the arrest affidavit that the authorities recovered a .40 caliber unspent round from the scene of the homicides that was located between victim number 1 and victim number 2's bodies, which was said to have extraction marks on it. An unspent round means the bullet was never fired but may have been loaded and extracted from the firearm chamber. And while police were executing a search warrant on Mr. Allen's residence, guess what? They found a Sig Sauer model P226 .40 caliber handgun, which Allen admitted he owned since 2001 and never allowed anyone else to use or borrow that particular weapon. Now, the Indiana State Police Laboratory examined the firearm and concluded that the unspent round located within feet of victim number 2's body had been cycled through Mr. Allen's Sig Sauer. Mr. Allen's attorneys stated in their documents filed back in December of 2022 that the discipline of tool mark identification is anything but a science. The entire discipline has been under attack in courtrooms across the country, and is unreliable and lacking scientific validity. They're not wrong. Tool mark identification is not really a real science. However, it will more than likely come in. I don't see this judge saying we're going to strike this from the legal system in this particular case or be precedent for getting rid of technique in the legal system. What the court's going to say is, well, it'll go to its weight, not its admissibility, and you can certainly bring in your own expert, or you can cross-examine the expert from the state as it relates to the validity of this tool mark analysis. We'll wait and see. I think that's what the court will do. Anyway, Mr. Allen is scheduled to appear again in court tomorrow, Thursday, and a trial date will be set at that time. And finally today, our dumb criminal of the day. So after this Minnesota man had his home burglarized last month, Blaze Smith anticipated that the intruder would likely return. So what did he do? Well, he left open a window and sat there and waited, armed with a baseball bat that was wrapped in barbed wire and studded with screws and nails. This is my kind of guy. Anyway, so the day after the April 15th break-in, the police charged Aldo Gomez because he returned to Smith's residence at the Eastwood Manor Mobile Home Park in Mankato, and he climbed through the same window he had illegally entered the day before. And when Gomez got inside the home about 9 p.m., he was confronted with Mr. Smith. Gomez fled the residence, and Mr. Smith pursued. Outside the mobile home, surveillance video captured Smith chasing and repeatedly hitting Mr. Gomez on the back of his head with a baseball bat. Now, the police noted that the bat was wrapped in barbed wire and had screws and nails placed in it as well. Needless to say, the blows left Mr. Gomez with a, let's just say, fractured skull in this particular case. It's just a flesh wound. That's what you get when you break into someone else's home. And when the police arrived at Smith's residence in response to the burglary, Mr. Gomez was sitting in the front yard bleeding. Gomez apparently only lives a couple blocks away from Smith's residence and was taken by ambulance to the hospital. Now, while being treated, Gomez reportedly admitted to burglarizing Smith's home and basically to returning again to burglarize the home. He was arrested. Mr. Gomez was arrested on a pair of felony burglary counts, one of which carries up to 20 years in prison. Now, when questioned about the beating, Mr. Smith told the police that after he reviewed his security camera footage following the initial break-in, he knew that it was Mr. Gomez from his build and the way he walks. And the police noted that Mr. Smith knows Gomez from prior interactions. But instead of contacting police, Mr. Smith took matters into his own hands and, well, in this case, a bat in hand, and waited for the neighbor to return. And the surveillance video recorded Smith clobbering Mr. Gomez after he left the residence. And Smith told police he only hit Mr. Gomez while he was burglarizing the inside of the home, and said that he didn't hit him outside, just the 4 times inside. Well, needless to say, Mr. Smith has been charged with a pair of felony assault with a dangerous weapon counts. The top charge carries a 10-year prison sentence. Yeah, so yes, let's get this straight. Mr. Smith, you can protect your home. You can protect your residence under most state laws. It's the castle defense, the make my day defense, whatever you want to call it. Somebody comes into your house, you have a right to protect yourself. Lying in wait, not a bad idea. If you know they're coming, you can take care of them that way. Check your local laws before you do anything crazy, though. And in this particular case, though, once they leave the house, you can't pursue them and beat them with your bat wrapped in barbed wire and that has screws placed in it. Then it's just a good old-fashioned assault. So, Mr. Smith, you almost got it right, but you didn't. So now you're facing up to 10 years in prison. So unfortunately today, you are our dumb criminal of the day. All right, that's all we have for you today. Hope you enjoyed the show. We'll talk to you next time.